All right, the final hearing this morning is from Johnson County, 129-221, Ahmir Kenyatta and Megan Florence versus Brittany Sopha. Probably mispronounced a lot of that, and I'm sorry. Anyway, who do we have here for the appellant?
If the court please, the appellants appear by Michael E. Whitsitt, their attorney of record.
And for the appellee?
When Your Honor, Andrew McGrew appears for the appellee.
All right, Mr. Whitsitt, you wish to reserve any time for rebuttal?
2 minutes, Your Honor.
That is granted.
Thank you. If the court please. This case involves a residential lease from Olathe, Kansas, and it was a single family residence. My clients were the tenants. It therefore is under the Kansas Residential Landlord Tenant Act. I'll refer to it as the KRLTA. And what my clients, the appellants, want in this case is a reversal of the trial court's finding that my interpretation is that the trial court found that there were 2 liquidated damages provisions in this lease, and that the less heinous, the smaller of the 2, was going to be enforced by the trial court 1 month's rent. The other provision in this 32-month or 32-page lease was at the very end in an addendum, and it provided for a $3,000 early out. I call it a penalty. That's of course not what it called it. The trial court judge called it liquidated damages, and we believe that under the KRLTA, there is no ability to provide for liquidated damages in a residential lease. And that's what
liquidated damages clauses are prohibited in residential leases.
Yes, sir.
You have an alternative. I mean, if you don't buy that, I mean.
Well, I did discuss it reluctantly in my brief, which is the idea that these have to be looked at. If you allow them at all, they have to be looked at critically in terms of whether or not, in substance, they provide a windfall to the landlord, as it did in this case. Because in our case at bar, the landlord admits having suffered no damages. In fact, the landlord found a new tenant at $2,550 a month instead of $2,335 a month.
You look at liquidated damages prospectively, right? Not after the fact.
If you allow them at all, you're talking, I think, about the Carruthers line of cases, and I don't think
if we're allowing this, 3,000 or even a 1 month's rent liquidated damages for an early termination, as your clients did. What's unreasonable about that?
Well, the windfall that the landlord.
There was a windfall here.
There clearly was, and the fact that, and we all understand, I think, that residential leases are not freely negotiated between the parties. It's a matter of landlords having the high ground. The tenants have to basically take what they've been offered by the landlords in the lease. And so it can't be treated, in my opinion, as it was in Carruthers. Instead, you have to look at the facts of the case when the breach, if you will, when the early termination occurs, and what then happens with the lease itself. I don't think there's any easy way to look at a liquidated damage provision under the KRLTA and find that, oh yeah, it's just clearly enforceable, as the trial judge in this case did. And it's in looking at the law, it looks like it's the Shoot case, the 2024 case that brought in a consideration of Carruthers, and then it ultimately found out or determined that unconscionability was the basis for throwing out the provision in Shoot. But in my experience, I've seen, well, Mr. Brand back in 1975 suggested that this was an acceptable provision to put in a lease. And in the 10 or so years I've been practicing landlord and tenant law, I've seen these repeatedly, and it's not practical for tenants to appeal these to your court or to the Supreme Court. It just doesn't make any sense. And therefore, landlords, again, have the benefit of having a provision that nobody's going to argue about. And in this case, the trial court judge didn't argue about it. He found it.
Is As I understand it, either payment required here, whether it was the $3,000 or the 1 month's rent, was to cover the expenses of reletting premises. And it had nothing to do with excusing payment for rent for the later months on the lease.
To be clear, the first provision, which called for 1 month's rent, that's all it said. It didn't say what it was for. It just said that's an early out fee. The later one, the $3,000 fee, yes, it talked about expenses of reletting, thinking about what they had to do, and it, more importantly, it didn't waive future rent. It said you've got to pay this $3,000, but that doesn't excuse you from the possibility of having to pay future rents if we don't rent the place out. So I think that later provision, which the judge did enforce, thankfully, was clearly, or should be clearly deemed to be unenforceable.
I'm not sure if I read this that way.
You're at the addendum?
Yeah,
I quoted
it
language.
doesn't excuse rent that's already accrued. But are you saying this allows the landlord to get $3,000 plus future rent?
Yes, and I quoted the language in my brief. If you want me to, I'll pull out the brief.
I can look at that.
Yeah, it shocked me too, but it doesn't matter in the sense that the judge didn't enforce it. He enforced the less heinous of the two provisions. And I think we've already discussed the fact that my clients, the tenants, notified the landlord they were going to get out early. The lease didn't end until December. It was May of 24 when my clients notified the landlord they were getting out. Both parties worked to get the property vacated. My clients left June 18th. On June 21st of 2024, the landlord had new tenants in place at higher rent, $2,550 a month instead of $2,335 a month. And nevertheless, landlord one time wanted to charge rent for the month of July, for which she already had a tenant and had backed off on that since then, and distilled it down to, well, no, the landlord wanted $3,000 for the early out termination, and Judge McEntee decided, no, $2,335 is what we're going to enforce, which is from paragraph 4B of the original lease.
Mr. Whitsitt, as I read the addendum, there was the requirement that even in addition to the $3,000 and the $2,300, that the tenant would be required to pay the remaining unused months in that lease.
That's the way. Well, it's a very long addendum, but it does say that.
So my question is, does that last part where it says you have to also pay the months that you're not living here anymore, but you broke the lease on, does that really affect the character of the $3,000 liquidated damages or whatever you want to call it, the early termination fee?
I think so. It makes it a penalty, basically. It doesn't serve to compensate for damages if the landlord is reserving the right to charge for future rents or any other damages the landlord might suffer. That makes it pretty clear that that provision, the addendum provision for $3,000, is nothing but a penalty, in my opinion.
You would like that to be our opinion.
Well, that would be the ideal, yes. Well, I find it interesting that we have to deal with all these provisions landlords throw into the leases when, to me, the KRLTA pretty clearly doesn't allow that kind of thing. And here I am arguing with you folks about that when I don't. I think the KRLTA is clear about that. And this business about bringing in Carruthers, I think, is inappropriate because that's the language that relates to commercial contracts, not KRLTA leases.
Well, is Carruthers relevant, though, in a discussion of what constitutes a liquidated damages provision?
Oh,
It's not analogous factually, but I mean, its discussion of liquidated damages seems to be the most recent and best discussion by the Kansas Supreme Court.
I agree. Clearly, if you're into that discussion about liquidated damages, but I guess our position, the appellant's position is those have no business being discussed in a KRLTA case. In a landlord-tenant lease, you can't slip in a liquidated damage provision. It doesn't work. Now, I think there's a lower ground that you could take in regard to, oh, okay, liquidated damages are okay if you do this, this, and this, and I outlined that in my brief, but I don't think it's right to go there because the KRLTA is different than commercial contract law. The bargaining power of the parties is distinctly different, and the only one who writes a lease is the landlord. And so that's why the KRLTA was enacted, to give some equality to these parties, the landlords and the tenants. And if we allow any kind of liquidated damages provision in one of these leases, we're effectively backing away from the benefits conferred by the KRLTA on tenants. I discussed several things that in my brief, probably more than I should have. Unconscionability, for example, I don't think it's necessary to get to unconscionability, although it clearly, this provision or these provisions in this case were clearly unconscionable because of the facts, the surrounding facts and circumstances. And I think I referred to this earlier, and it's the unique facts of this case make it clear that the landlord got windfall out of this provision. If it's enforced, the landlord gets $2,335 in addition to rent that she never lost in the case. In fact, got the benefit of higher rent because my clients backed out of the lease early. Does this time include my rebuttal, or is this?
No,
This is 13 minutes?
rebuttal.
Okay. And I talked in my brief about measure of damages for the breach of a lease. And I think another factor that needs to be considered is the KRLTA does contain, I think it's in 2547, a provision for mitigation, a requirement that the landlord mitigate its damages. Well, if you use this liquidated damage provision, where does that mitigation duty go? I think it goes away, and that's not right. The statute again requires the landlord mitigate. That's really, I think, the substance of my argument. Thank you.
Thank you. Mr. McGrew, let me just lead off with a question. If your client hadn't rented this property out so quickly, would she have been allowed to sue for the $3,000 plus the unpaid rent that was never paid?
The forward rent after the termination date? I don't believe so, Your Honor. I do believe that the language of the addendum, to the extent that it can be read as requiring future rent, I believe it's unenforceable. I think it's just the product of poor drafting rather than something that they would try to enforce.
We're talking about the sentence, tenant is still responsible for all obligations under the lease, including paying for all rent due, damages, and other charges, right?
Yes, Your Honor. I believe that was intended to say that up until the termination date, the tenant would remain responsible for the rent up until then, but not require them to pay ongoing rent in addition to the liquidated damages provision. I certainly would have drafted it better myself, but I think that was the ultimate goal there.
Well, it wouldn't be much of a liquidated damage clause if it allowed the double recovery, right?
Absolutely correct. And to the extent that that is a potential problem here, I believe that can be removed. It's an unenforceable provision in the case of a liquidated damages, but it can be removed without affecting the rest of the addendum, which I believe squarely does provide for those liquidated damages. The primary issue in this case is really not even about actual damages or settlement, it's about whether or not the parties can settle their agreements at any point during the relationship of the parties. Strictly, just as a matter of public policy, it's really in the best interest of all parties, landlords, tenants, and the judiciary, to allow these liquidated damages or early termination fees to be enforced. They are advanced settlement agreements made in the anticipation of the actual damages that will come up in the event of a breach. Arguments about security deposits, actual damages, all of these things, windfalls, these are all red herrings because they don't actually go to the main issue. The crux of the issue is the ability of the parties to enter into a settlement agreement to resolve their issues.
In looking at Crothers, again, not as analogous factual authority, but as a good discussion of liquidated damages clauses, it seems to indicate a liquidated damage clause must resolve all damages flowing from the breach. Would you agree with that?
I do believe that's correct, Your Honor. I believe that the intended goal for a liquidated damage clause is to, as the court set out in Crothers, the three main goals are to encourage settlement, to avoid litigation, and to allow the parties to live and operate under their agreement.
By providing a fixed dollar amount resolves all damages flowing from the defined breach.
Correct.
I'm having a hard time, and help me here, why either provision in the lease for the payment is then a liquidated damage, because it does seem to allow the landlord to continue to seek unpaid rent through the balance of the term if they're unable to mitigate. They take reasonable efforts and can't, but they still are able to, or I mean, there's an acceleration clause that allows to sue immediately for the unpaid rent on the balance of the lease term. So explain to me how these wind up being liquidated damages clauses.
Well, so I think that it would, and again, I do believe that's kind of the product of just poor wording. I believe that the intent was to just require.
Well, except that what we look at is the wording. I mean, it's a written contract, and the landlord had whatever ample time to do this. Obviously, somebody spent a lot of time on it, and it. I mean, we are in this situation probably to strictly construe it against the landlord as the maker. So, I mean, poor drafting doesn't seem to me to be a defense here.
Well, and so I think that it does go more towards the attempting to construe or to garner the intent of the parties as it was when they entered into the agreement. This was originally drafted with the intent of fully resolving the issues between the parties to the extent that there would be a breach or there would be an early termination of the lease agreement.
Well, how do you read it that way?
Absent the provision that allows the recovery of future rent, had that provision been removed, if that is judicially removed, and the rest of it is remained intact, I believe it falls much more closely.
Right. We're supposed to look at the intent of the parties based on the language in the contract, not what we strike out as being legally unenforceable, right?
Correct. And
I mean, how does that, I mean, the intent was, geez, the court looks at this and says, this is really bad. We don't mean it. I mean, that's your argument, isn't it?
not necessarily, Your Honor. I do believe that the crux of my argument is that the parties intended for there to be some remedy if there is an early termination. So if there is an early termination, there's an amount that would be paid. I believe if my client did try to recover rent beyond that period of time, that would be invalidated by the contract interpretation. But they did not try to recover any rent after the period of termination. They're just seeking the early termination fee that the parties agreed to.
Well, that's because they had no damages. I mean, but I had something disappear. Go ahead.
If we don't allow the enforcement of the clause in this case, has your client suffered any actual damages?
Well, Your Honor, I think the care of this court does provide instruction on that, to where the retrospective analysis is not one that should be considered in liquidated damages. So to the extent that the liquidated damages is completely, or sorry, the early termination addendum is completely removed from the agreement, Um, my client in this particular case has not suffered any damage.
So I guess what I'm getting at, if there would not be any need for us to remand this back to district court for a determination of actual damages, you're basically conceding there is none. Is that right? I'm not forcing.
No, I want to make sure I'm giving you the correct answer. I don't believe that there are any actual damages. My client was fortunately able to re-rent the property fairly quickly. However, that's not always going to be the case. And these kinds of provisions help protect not only landlords, but also tenants from the uncertainty, the difficulties that come along with trial, with litigating these issues. For example, if we picture a situation where these liquidated damages are not enforceable, or if they're not permitted under the KRLTA, like the appellant's arguing, we would be in a situation where immediately upon the tenant's notification, hey, terminating my tenancy early. I know it's only been a couple months, but I have to move across the country, or I'm starting work somewhere else. All of a sudden, the landlord has to file a lawsuit immediately, even before the termination date, which is permitted by the KRLTA. The first appearance date, tenant likely hasn't moved, and so they have to request a continuance. So immediately upon filing of this action, there's already 2 court appearances that are required. And then no decision can be made. Nothing can actually happen until the landlord re-rents the property and determines their actual damages. So we may have 3 to 4, 5 different appearances, at which point the tenant's going to be frustrated, arguing that you're not making reasonable efforts. You should reduce the rent. You should advertise more. You should make more of an effort to be available. And then all of a sudden, the district court is in a position where they are having to determine what's a reasonable rental value for this property. What are reasonable efforts? If the interest rates go up, or if there are added expenses for landlords in this case, how much or what's a reasonable value? And all of a sudden, the district courts have to become real estate professionals rather than legal professionals. And so it gets to a point where after 5, 6 appearances, the tenants probably had to miss work to make these court appearances. The landlords had to hire an attorney, and they're several $1,000s in the hole. At that point, the parties say, we need to put a cap on this. I'm tired of coming back to court. I'm tired of spending this money. Let's just resolve the case now. I'll pay you a month of rent, a month and a half of rent, just to make this go away. The landlord stops incurring damages. The tenant stops having to miss work. The tenant's future damages are stopped at that point as well. And so we end up in the same point that we would have been had the liquidated damages be enforced and been enforceable under the KRLTA. And so for these reasons, these kinds of provisions protect the landlords. They protect the tenants from possible expenditure, and even protect them from, none of my clients would do this, of course, but potentially uncouth landlords who would want to charge more, want to possibly, as Mr. Whitsitt suggested, might overcharge. And if they don't get a new tenant in there, so be it. They have someone on the hook for actual damages.
So what about the circumstance? Now here you have the tenants moving up halfway through the lease, roughly. So there's like 6 months, and it's a fairly significant rental payment. If you had a liquidated damages clause like you're describing, is it reasonable, though, to apply the liquidated damage to someone who moves out, say, it has an exigent circumstance and has to move out in the 10th month of the 11th month, as opposed to someone who's voluntarily taken off halfway through the year?
In the situation where the liquidated damage provision, it would be very fact specific. So for example, in a situation where they require 30 days advance notice of the termination, if you're in the 11th month and the lease is getting ready to expire, depending on the language of the lease, the landlord may say, well, they haven't provided their notice of intent to vacate yet, so the lease is going to renew for another year or another 6 months or whatever period that might be. In which case, if the tenant hasn't provided notice and suddenly has an exigent circumstance, they would be in a situation where the landlord's already anticipating an extension of the lease based on the terms. Now,
Take that out of it.
Sure.
That's not in the hypothetical.
In the situation where the lease would come to an end, then in the event that it gives the landlord a windfall, I would argue it's not enforceable. The tenant would be responsible for paying their rent up until.
Isn't that a retroactive examination that we're not supposed to make?
Not necessarily. I think that this is distinguishable. It is still a retroactive examination, but instead it goes to the conscionability of the provision. And so to the extent that, for example, if a tenant leaves 2 weeks before the actual termination date of the lease, and the landlord says, well, you owe me a month and a half of rent, then at that point, they wouldn't have otherwise been entitled to those amounts. And so it does require some kind of finessing at some point. But in the case of Bar, there are several months where the landlord was anticipating to have this rental income, was planning on it.
My limited experiences that limited actions do a lot of finessing. But
And I do believe that would probably have to be the outcome there, in which case it's very reasonable for the parties to come to court and have that conversation, should that be necessary. But in a situation like this, where there's 6-7 months left on the lease agreement, the landlord isn't anticipating the potential non-renewal of that lease. So they're anticipating 6 to 7 months of actual tenancy, actual income. And in the event that that's suddenly removed and taken out from under their feet, they have to scramble. They have to try to locate a new tenant. And in this particular case, the landlord is not a professional landlord. The landlord is an individual. She has a full-time job, works regular hours, leaving the only time for her to act as a landlord or property manager in the evenings and on the weekends. Severely limits her ability to get new tenants, to locate and bring them in, which goes towards the enforceability of this particular provision, because the landlord needs to have that added security. She'll need that extra time to try to bring a new tenant in.
Counsel, I just want to make sure here that you do not have a Kansas Supreme Court or Court of Appeals case that upheld a liquidated damage award in a KRLTA case.
That's correct, Your
Is that
Honor.
fair?
That's correct. So this is, I believe the closest is Carruthers, not directly on point, but I do believe that is instructive for purposes of determining the public policy, which is to encourage settlements, to avoid litigation, and to allow the parties to enter into these agreements and live by them. For those purposes, I believe that tenants and landlords in the residential aspect do have those same interests. They want to resolve the cases without having to come to court several times. They want to avoid the cost and the uncertainty and the potential several months that could go by where a tenant might be on the hook, even if the landlord is actually using reasonable efforts to re-rent the property. To that end, we believe that this provision is reasonable, that's enforceable, especially in a KRLTA situation. And if the court has any other questions, I'm happy to try to address them.
Apparently not. Thank you.
Thank you.
Just a couple of things, if I may. I think that the appellant's position, which is we want a clean line. Liquidated damages provisions and KRLTA leases are not acceptable under the law, is the way to go. There are subtle ways to get around that, and I talked about that in my brief, but I don't want to belabor that because I think the right answer, because of landlords, and my worthy counsel here has highlighted the fact that landlords are creative. Since 1975, when we got the KRLTA, they've been working ways around the prescriptions of the KRLTA, and if this court or the Kansas Supreme Court allows them any wiggle room, they're going to take advantage of all of it.
If I was a tenant, I'd want a liquidated damages clause. Anything to get me out of being responsible for the entire lease. That seems reasonable and fair to me.
Believe me, some do. I've talked to some who preferred the liquidated damage approach to paying me, if you can believe that. I know that's hard to believe. And I think that counsel's discussion about protracted litigation is just, it's imagination, a good imagination on his part, because I don't know of any landlords, in my experience, who will file an eviction or sue for damages before the tenants actually left the premises. That's a very creative scenario that he presented to this court, which in my experience doesn't exist. Thank you very much.
All right, counsel, thank you both for your briefs and your arguments. We'll take it under advisement and get an opinion out to you as soon as we can.
Thank you.